Hello, welcome to this video on the Section 20 GBH and wounding. This is the 4th out of 5 non-fatal offences videos. So to start us off, we're going to look at some information on Section 20 GBH and wounding. Now this is the second most serious of the non-fatal offences found in the Offences Against a Person Act 1861. The most serious we look at is Section 18 GBH and wounding. So this is still a triable either way offence, and the maximum prison sentence is 5 years, just like it is in ABH. So the definition then comes from Section 20 of the Offences Against a Person Act 1861 and tells us, whosoever shall unlawfully and maliciously wound or inflict any grievous bodily harm upon any person, either with or without a weapon or instrument, shall be liable to 5 years imprisonment. So therefore, the offence of inflicting GBH or malicious wounding is defined as occurring where the defendant unlawfully and maliciously wounds or inflicts any GBH to the victim with or without any weapon or instrument. So what we've done here is broken down the constituent elements. So we've got the actus reus of Section 20 GBH, and then we've got the mens rea of GBH too. So we're going to begin with the actus reus, and of course we've got this concept of unlawful, so it must be an unlawful infliction, and this wounding or GBH. Well, unlawful just means that there is no consent to the act. Now, subject to age restrictions set out by the statute, it's not unlawful, for example, to have a tattoo or piercing, so long as consent is genuine, amongst other examples. So in terms of infliction, this word really just means to cause or to bring about. So the infliction, this wide definition initially, so from Lewis in 1974, the defendant shouted threats at his wife through a door, tried to break through. Now she jumped from a second floor flat window and broke both of her legs. And the defendant was convicted of Section 20 offence. Now there was an assault and therefore the causation of the GBH. Now there doesn't need to be a technical assault, as in battery. So there can be an assault such as silent and abusive phone calls, hate mail and stalking, which in Bairstow cause severe depression. And the victim's actions led to a consequence, and the defendant was guilty of the offence. So following the case of Bairstow, we know the House of Lords confirmed that Section 20 offence can be committed by, for example, direct acts, indirect acts, omission, by someone inflicting psychological injury upon another, and indeed the word inflict just means cause, or they're quite interchangeable. Now, to this end then, if it does mean causation, that does mean that infliction needs you to prove factual and legal causation in any scenario question. So as mentioned before, Lewis caused the Section 20 offence, or the injuries in this case, breaking both of her legs, by shouting through a letterbox and causing some fright. In Halliday, again, the defendant's behaviour frightened his wife so much that she jumped out of the bedroom window to get away from him. Now, the injuries she suffered as a result were found to be directly applied, so he could be charged under Section 20. In Deaker, this is one of the first cases in which somebody infected somebody with HIV and was convicted. A man knew he was infected with the HIV virus. He persuaded two women to consent to unprotected sex, each on more than one occasion, without telling them of his condition. Now, they were both subsequently diagnosed HIV positive, and the defendant was convicted of causing them GBH, contrary to Section 20. Now, the Court of Appeal quashed his conviction and ordered a new trial, but confirmed that conviction is possible in circumstances such as these. In Bairstow, again, we've looked at this already, but the victim suffered severe depression due to the behaviour of her stalker. Now, the defendant was charged with inflicting GBH when he caused his victim psychiatric harm by stalking her. He sent a hate mail, made malicious telephone calls, stole garments from her washing line, and then passed on intimate personal details about her family. Now, the question arose as to whether he had inflicted the harm. And as we have seen already, the word inflict and cause should be treated as interchangeable. So once we've addressed the infliction element, we need to consider, what was the injury? Was it a wound or was it GBH? We're going to look now at wounding. So we know unlawful wounding or inflicting GBH, the defendant is either charged with one or the other. Now, if he's done both, the prosecution must choose which one he's charged with. Of course, it's probably easier to go for the GBH because something can be categorised more serious, especially knowing what we know next about unlawful wounding. So, wounding was defined in Eisenhower as a wound is a break in the continuity or the surface of the skin, or indeed both layers of the skin. So in Eisenhower, or JCC and Eisenhower, a child was shot by an air gun. Now the pellet ruptured the blood vessel in the eye, causing internal bleeding. Now, since the victim suffered internal injuries, but crucially no breaking of the skin, this didn't amount to an offence under Section 20. Now, there was no break in the skin, so therefore there was no wounding. And then we have Moriarty and Brooks. In this case, a landlord of a pub struck the victim in an attempt to evict him from the pub, and the victim suffered a cut under the eye, and the defendant was found guilty of GBH or wounding under Section 20. So we know the definition of wounding, and we of course need to apply that. Now, it might be easier to categorise an injury as GBH because all GBH is serious harm. So we start off with this concept of really serious harm from the case of Smith in 1961, but this definition has moved towards serious harm from the case of Saunders in 1985, and can, like ABH, include psychiatric harm. Like any physical harm, levels of psychiatric harm differ too, and can be more serious and therefore categorised as GBH. If we look at Bollum, now in this case the defendants caused severe bruising to a 17-month-old baby. Now the Court of Appeal held with the victim's age and health are relevant when deciding whether an injury amounted to GBH. So what you have to do here is assess the effect of the harm to that particular victim. So this could be the case if a person is also particularly old or any other infirmity. It may be considered. So we got Medland as well. Pouring petrol over a victim in this case and setting it alight, of course, amounts to GBH. In Ishmael, throwing nitric acid into the victim's face and causing disfigurement was considered GBH. Very serious. And in Deakin, again, we know this was GBH, though he was found not guilty for various reasons. In this case, it was certainly GBH, HIV, or passing HIV on to somebody could be considered GBH. In Brown and Stratton, we have a victim who was a cross-dresser who went to the market store where his father worked. Now, the father felt humiliated to see his son as a woman, and along with his cousin, attacked the victim with a chair, causing a broken nose, 3 lost teeth, and a concussion. Now, the combination of the injuries here is held to amount to grievous bodily harm. So what we got there is several lots of ABH, if you like, could be considered GBH. Again, in Burstow, mental injuries were considered enough for GBH in this case. And in Martin, the defender was blocked the exit of a theatre in this case as a prank and turned off all the lights, and several people were injured as he shouted fire. They all rushed to the door, and again he was convicted of Section 20 GBH. In Marjoram, very few of these cases so far, people jumping from windows, but of course the defendant forced the victim in this case to jump from a 3rd floor window to escape harm, and such injuries and actions were foreseeable, and therefore he was guilty under Section 20 of the Act. So once we've established the actus reus, so it's an unlawful infliction of wounding or GBH, remember this one or the other, we need to go and look at the mens rea of the offence. Now, put simply, you have intention for the act. It can be either direct or oblique, or indeed it can be reckless, so we're taking a subjective risk as to whether the wound or GBH can be committed. So the mens rea means malicious wounding or malicious infliction of GBH. So it must be done maliciously. Now, maliciously comes up quite a bit in criminal law, but this just means intentionally or recklessly causing some harm in this case. It's not necessary to consider the level of harm, okay? The mens rea of this offence in Section 18 is the difference between the two offences. This is about causing or intentionally or recklessly causing some harm. We don't have to foresee the eventual result. So the defendant must prove then either the defendant either intended their act to result in some unlawful bodily harm to the victim, or was subjectively reckless as to the risk that his act might result in such harm. So we can look to the case of Cunningham as an authority here. Now in this case, the defendant tore a gas meter from the wall of an empty house in order to steal the money in it. Now this caused the gas to seep into the house next door, where his future mother-in-law was affected by it. And Cunningham was charged with the offence under section 23 of the Offences Against a Person Act 1861. Not an offence we look at, but of course it proves a point. Now this offence was maliciously administering a noxious thing, essentially poisoning. Now it was held that he was not guilty since he didn't realise the risk of the gas escaping into the next door house. Now he hadn't intended to cause harm, nor had he taken the risk that he knew about. So in this case, he wasn't even subjectively reckless, and so therefore was not guilty of the offence. Now malicious doesn't mean wicked then, so intent is required. That was the key point from this case. We've also got a case of Belfin. Now the defendant in this case pushed the girl to the ground, and he and an accomplice attacked those who came to help her. Now the defendant slashed one man with a razor, causing severe wounds to his head and chest, and was charged with wounding with intent. The Court of Appeal quashed his conviction under section 18 and substituted a conviction for section 20, unlawful wounding. Now he had certainly foreseen the risk of such consequences, but it couldn't be proved that he had specific intent, which is the basis for a section 18 offence. In Moat, the defendant struck the victim several times, knocking him unconscious. Now the defendant's companion had actually taken money from the victim, and the victim had seized the defendant by the lapels and demanded to know where the defendant's companion was. And the principle here is intention or recklessness as to the wound or GBH need not be proved. It's enough that the defendant foresaw that some physical harm to some person, albeit of a minor character, might result. So what you might consider then is the intention for this offence is a little bit lower. If you look at this, what we're seeing is some harm, which I suppose technically could be ABH. So the mens rea level is a little bit lower than the harm that actually occurs. So that's a bit of a theme in these offences. Now in Parmenter, the defendant injured his 3-month-old baby when he threw the child in the air and caught him. Now the defendant said he often did this with his older children and didn't realise the risk of any injury. And again, the defendant was found not guilty. He hadn't intended or been reckless, i.e. realised some risk and took the risk anyway, as to causing some harm. So of course, didn't satisfy the subjective recklessness element, which is required for the offence. Now we looked at the joint charging standards when we did the ABH, but for this, the joint charging standards have agreed that the offences would normally be charged under section 20, and these are the kind of issues. So injury resulting in permanent disability, clearly that's very serious. Permanent loss to any sensory function like blindness, deafness, and so on. A significant permanent visible disfigurement. Broken or displaced limbs and bones. For example, compound fractures, broken cheekbone, fractured skull, broken ribs, broken jaw, etc. Now, injuries causing substantial loss of blood would also be considered GBH, and injuries resulting in lengthy treatment or lengthy spell of incapacity. So there are then different ways in which the offence can be committed. We've got either intentional wounding, intentional infliction of GBH, reckless wounding, or reckless infliction of GBH. We need to work out what it is before we go through those elements when we're applying the law to any particular scenario or question. And that's the video. So section 20 GBH of wounding, we've got the actus reus. We looked at the idea that can be unlawful infliction and it's a wound with GBH. And then with mens rea, we've got intention or recklessness to commit for some harm. Now of course, if you were to go deeper into intention, direct or oblique, as in what makes up those levels of mens rea, then you should look at the mens rea video to explore that a little bit further. Thanks for watching.